Hello and welcome back to another video on this YouTube channel. Today we're going to be looking at Rylands v Fletcher, which is a tort on the paper 2 of the OCR specification tort law. Rylands v Fletcher was established in 1868. It's quite an old tort. It's often described as a subspecies of nuisance, but it can be clearly defined as a separate tort to nuisance, and certainly in questions before it can be expected to come up separately. So there's nothing to say it couldn't come up together, but it's often treated as a separate tort on the exam and the specification, so I would expect it to be so. The case, essentially, the defendant built a reservoir, as you can see from this sort of picture on the top left there, and the contractors he hired found a disused mine shaft and didn't seal it properly, so it was sort of negligence there. They then filled the reservoir up, and of course what happened is the water came down the mine shaft and escaped into the claimant's mine, causing significant physical damage. In this case, the House of Lords established essentially a four-part test, as you can see on the left there, which is that D brought something onto his land, known as accumulation. It was a non-natural use of the land. The thing likely to do mischief if it escaped, otherwise known as dangerous, and the thing did escape and caused reasonably foreseeable damage. Now, if we look at the case, those four parts of the test in terms of what happened here, in this case, the defendant brought on a large body of water, so that water was brought on artificially and it was accumulated there in the form of the reservoir. It was a non-natural use of the land, which we'll explore later, but essentially means it's not a commonplace use of the land. And certainly a large reservoir wasn't a commonplace use of the land, so it was deemed to be a non-natural use of the land. The thing was likely to cause mischief or do mischief if it escaped, and they said, well, of course, a large body of water it's dangerous if a large body of water does escape in that fashion, and it did escape because it crossed the land boundary into the claimant's land and property and caused significant physical damage, and of course that damage was reasonably foreseeable given the context of how it escaped in through the mine shafts, etc. Now, looking at the first part of the test, D brought something onto his land accumulated here. The key thing here is that the defendant must have voluntarily brought something onto his land and kept it there, and that's, as I said, known as accumulation. So in Rylands v Fletcher, as we said, the water was brought onto his land in the form of a reservoir. Now here, it's got to be artificially brought on. It cannot be a natural accumulation. So, as we said in Rylands v Fletcher, the water wasn't naturally accumulating in a normal lake there through rainwater. The reservoir was built artificially, and then the water was brought and filled up with the reservoir was filled up with the water. So it was brought onto the land and accumulated there. So you've got to distinguish that from natural accumulation. So in Giles v Walker, thistles naturally accumulated on the land as weeds. He didn't grow them there, he didn't bring them there. They just naturally accumulated, and then they blew across onto the neighbour's land and damaged his crops, and they said that was not a case of Rylands v Fletcher. It wasn't a successful claim of Rylands v Fletcher because the thistles had naturally accumulated on the land. The defendant hadn't brought them on there and accumulated them there. It was a natural accumulation. Equally, in Ellison v MOD, rainwater naturally occurred on the land, and then they did some construction work which caused it to run off and cause some damage. But again, they hadn't brought water there in the form of a reservoir. It was rainwater that was naturally accumulating on the land. So they said, no, that's not a case of Rylands v Fletcher. Non-natural use of the land. This is an interesting area. So this is a legal definition. It doesn't mean artificial, in contrast to the bit we were just looking at. And that's where sometimes students get confused. You've got to treat this as a separate bit. This does not mean an artificial use of the land. What it actually means is not a commonplace use of the land, which is slightly confusing given the name, but you've got to remember there that it's a legal definition of what that means. So it's not commonplace. So I describe to my students that means you wouldn't necessarily expect to see it there. It's an unusual thing to have there perhaps, or not a very commonplace thing. So in Rylands v Fletcher, a large reservoir was deemed to be a non-natural use of the land. They're not everywhere, they're not often thing you'd have a big large body of water like that that's artificially put there. The classic, and they did say this in the case in Cambridge Water v Eastern Counties Leather, they said the storage of chemicals and solvents in that case, that is the classic example of a non-natural use of the land. So that's a really good case example to use there. Equally, in Mason v Levy Auto Parts, storage of petroleum, petrol, paints and inflammable material was deemed to be a clear non-natural use of the land. So they're two really good cases alongside Rylands v Fletcher to demonstrate non-natural, not commonplace uses of the land. Equally, a case to distinguish where it was deemed to be a natural use of the land, so not a non-natural use of the land, was Rickards v Lothian, where water was supplied to a building via pipes, water pipes, and they said, well, look, this is really commonplace. Every building has that, in some form. It's certainly apartment blocks and big buildings like that. They all have pipes, and that's the weird thing, because actually that is clearly an artificial use of the land. Pumping water vertically up pipes against gravity is clearly artificial, so you would think, oh, it's a non-natural use of the land clearly then on that basis, but remember, that's not the definition. The definition is that it's not commonplace, and actually water pipes up buildings are very commonplace, so they said that's not, that doesn't meet the test here, so that wouldn't be a case of Rylands v Fletcher. 3, the thing is likely to do mischief if it escaped, so it's classed as dangerous. So this is often referred to as the defendant kept at his peril. Clearly, in Rylands v Fletcher, a large body of water is likely to cause mischief if it escapes. And really, the defining feature of this element of this part of the test is that really there's no clear definition, but it's likely that lots of things are going to be considered to be dangerous by the courts. They basically do it on a case-by-case basis, and lots of things in certain contexts can be considered dangerous. So in Schiffman v. the Order of the Hospital of St John of Jerusalem, a flagpole, just a simple flagpole on a building, was held to be likely to cause mischief if it escaped, because whilst a flagpole inherently by itself is not dangerous per se, if it escapes, if it falls off the building, then of course it is. Equally, in Hale v Jennings Bros, a chair airplane ride, which if you imagine a fairground and you think of a sort of a roundabout, but actually the ones with the sort of chains that hang down with the seats on and swing round, that's a chair airplane ride essentially. In this case, one of those chairs came off and flew off and hit a stool and caused some physical damage and actually injured someone. And that was held in that context, of course. Well, yeah, that is likely to do mischief if that chair flies off. Of course it is. So it's clear that most things, or a lot of things, would be considered to be dangerous if they escaped. So it's quite an exhaustive list there. Finally, in terms of the final bit of the test, is the thing did escape and caused reasonably foreseeable damage. So there's 2 things to this. The first thing you've got to establish is that it did escape, and secondly, that it caused reasonably foreseeable damage. So the main case on this is Reed v Lyons, which held that escape meant crossing a land boundary. You could see that really clearly in Rylands v Fletcher when it went from the defendant's land through the mine shaft into the mine of the claimant. So it has to cross that land boundary. In Reed v Lyons, it was held that it didn't. It was to do with the munitions factory. It makes ammo or that sort of thing. And the shrapnel that exploded, there was an explosion in the shrapnel that actually went. It never actually crossed the land boundary. So it wasn't a case of Rylands v Fletcher, the judge said. Two odd cases that stand out here are Miles v Forest Rock Granite. In this case, no actual material crossed the land boundary, but the shockwave, the blast, did. And in this case, the judge held that was actually sufficient. So that's one sort of an exception to look out for in scenarios. Equally, in Hale v Jennings Bros, which is quite an important case for 2 reasons, they held it to be sufficient even though the chair that flew off didn't actually technically cross a land boundary. They said, that's fine. It did escape still, according to the judge in this case. Even though it didn't cross the land boundary, I guess it hit another stool, so that might have been a part of it. There's a really key bit here in red, which was also unusually able to sue for injury. So this Rylands v Fletcher is largely about suing for physical damage. That's the rule. That's what it's about. But in this case, they held that actually someone could sue for injury as well. So it's a very unusual case, but worth remembering, particularly in a scenario if there is injury. It's really worth using this as a case example to back up that in some cases it is possible to sue for injury, although the vast majority will be for physical damage. Finally, on this bit, damage caused must be reasonably foreseeable, and this is a really easy bit to miss out, but actually it's really important that you don't, because it can have a huge impact, as seen in Cambridge Water v Eastern Counties Leather. In that case, basically a small amount of solvent over time was dropped on the floor of this factory, and it went through through the concrete floor, down to a hard bit of rock, travelled along that bit of rock about over a mile, and then polluted a borehole. So actually, if you went through the test, D did bring those chemicals onto his land and accumulate them there. storage of those chemicals was clearly a non-natural and not commonplace use of the land. Chemicals are clearly likely to cause mischief if they escape because they are, toxic to organic life and all that sort of thing. And they did escape clearly. They crossed the land boundary, several land boundaries, no doubt, across a mile. But ultimately, the court said it was not reasonably foreseeable that would happen. We're talking about a very small amounts of solvent or sort of chemicals going through a concrete floor, travelling, a mile and polluting a borehole over a mile away. So they said it just wasn't reasonably foreseeable. So although it met actually most of the test, it failed on this last bit, which shows that it's so important to make sure you consider this last bit. It can be really a defining part of your answer. Before you reach a conclusion in the scenario on this, it's really important that you consider any relevant defences. There are 6 that you could consider. 3 of the most popular ones are acts of a stranger, act of God, and common benefit. The others are less popular, let's say. Acts of a stranger is to do with the unforeseen and deliberate act of a stranger. It can be seen in the case of Rickards v Lothian, which actually we know failed anyway because it wasn't a non-natural use of the land. But they also said in this case, well, actually, a stranger came on, and what happened in the case? A stranger came on and blocked the sinks up and toilets up, and it caused flooding to a neighbour's property down below in a flat, I think, essentially. And they said, well, look, we didn't foresee this. There's no way we could have foreseen this act of a random stranger doing this, and they did it deliberately. So they said, actually, you could have used that as a defence anyway, should it not have failed already on one part of the test. So if it had gone all the way through with that, they would have been able to use that defence. Act of God is a bit of a more tricky one, especially nowadays. There's 2 distinguishing cases here. If we look at Nichols v Marsland first, they diverted a natural stream to make some ornamental lakes. There was then exceptionally heavy rainfall, which caused significant flooding and damage to their neighbour's property, the claimant's property. And the court held it to be an act of God. The 2 key things here: there was no negligence in the construction or maintenance of the river. They'd done it in a good way by those standards. And the flood, they said, could not have been anticipated. The heavy rainfall, exceptional flood, couldn't have been anticipated. Bear in mind it's 1876. If you contrast that with Greenock, Cork v Caledonian Railway, in this case they diverted again a natural channel or stream, river. They obstructed the flow of water. They kind of knew they did that. There were multiple floods where there was flood and they could see that they'd obstructed it and that was causing flooding. And they basically hadn't done the work adequately. And the judge said, you can't use act of God here. The flooding was essentially anticipated, and the construction and the maintenance therefore was possibly negligent or at least not done adequately, so therefore you couldn't use act of God. Key thing with act of God is it's about anticipation. Could you have anticipated and done something? With modern weather forecasts and things like that, it's about the anticipation of that extreme weather event and also the preparation you did. What did you do to try and mitigate it? If you knew it was going to happen, did you tie down a lid, or did you prepare in any way, sandbags? There's all sorts of things you could do to mitigate any damage by flooding or other things. And act of God, it's largely weather, so you could be talking about rain or storms in most cases. It could be thunderbolts causing fires and things like that, which is a bit more of a tricky bit. Statutory authority, the key case here is Green v Chelsea Waterworks Company. In this one, a water main burst to cause physical damage, but Chelsea Waterworks were actually under a statutory obligation to maintain a really high pressure in the water main, which caused the issue, and they were held to not to be liable because they basically had a statutory authority to maintain it at that high level, so they weren't liable. It's a bit of an unusual one, that one. Certainly in the scenario, it'd have to say that there was statutory authority. It'd have to mention some sort of statutory authority in the scenario for that to be relevant, so it should be an easy one to pick out if it was. Consent, in this case, Peters v Prince of Wales Theatre. Sprinklers caused flooding into the claimant's property. But the court judge held that the claimant consented to the use of the sprinkler system because it was when they went to rent or lease out the building, the sprinkler system was in there. So essentially, they knew that they were getting it with the sprinklers, so they were therefore held to have consented to it. And also, there was a benefit to both of them there. So in terms of stopping fires and things like that, so they said no. Common benefit is a fairly popular one that could come up in a question. There's no case per se that I've got on here. Certainly water pipes provide a common benefit, which would be a sort of element of Rickard's v. Lothian at the top there as well. But also there's things in questions before like to do with recycling plants and things like that, and it's something certainly worth mentioning that it would be considered. Whether it be a full defence or not is another question, but it's certainly something that I would consider if you think it's relevant, and at least mention it in the exam as a potential defence or something to be potentially considered. Finally, fault of the claimant, Ponting v. Noakes. In this case, a horse leant over a fence and ate some material off a yew tree, which was poisonous, and the horse unfortunately died. And the court, one of the defences was essentially, well, it's the horse's fault because it wrongfully intruded on the land, and therefore de facto it was the fault of the claimant because it was the horse's fault, which is a bit unusual. But there you go. So it's a bit of an unusual case that, and it's a bit niche, I would say. So I wouldn't necessarily expect something on that per se, but certainly worth knowing and just looking at, is it the fault of the claimant in some capacity? And finally, it's worth looking at the remedies. It's always worth mentioning this at the end of a question. If you find that there's a successful claim for Rylands v. Fletcher, then it helps to then suggest what perhaps the appropriate remedy would be. Often in cases like this, it's going to be physical damage, so you're talking about damages in terms of general and special damages, and if you can articulate any specifics there around whether it would be general or special or both, and for what reasons, that would be very beneficial. And equally, it's possible to sue for damages for injury, as we saw in Hale v. Jennings Bro. So it's certainly worth mentioning that and referencing that case, although it's much more unusual. So you just need to watch out for that in the question, looking out for specifically injury, and then referencing that at the end in your conclusion. Hope you found that video really useful. Please subscribe to the channel. It really helps me create more of these videos, and would be great to join. And please leave any comments and feedback if you want to see anything particular in the videos, or you'd find anything helpful. I'd be very useful to hear that, and hope you enjoyed. Thank you very much.